The hearing on this application is being held by way of video conference. Any orders or directions made after or during the course of this application will be issued by the Registry in Dubai on the appeal bench instructions. We are here for a hearing in the matter of CA-001-2020 before Chief Justice Zaki Azmi, His Excellency Justice Madhani, and Justice Roger Giles. The claimant is represented by Banks Legal Consultancy. Lead counsel is Roger Galvin. The respondent is represented by Taylor Wessing. Lead counsel is Tom Montague Smith, QC.
Okay, gentlemen.
Good morning.
We have gone through your submissions, which you have submitted to us. And from the looks of it, that we think that unless, of course, Mr. Counsel have anything to say, we think Mr. Akalaje should be allowed to join in for the purpose of cost. Any objection from either of you?
No, sir.
Okay, if that's the case, then we put on record that Mr. Akalaje is now joined as a third party as far as cost is concerned. So, Mr. Montague, you want to start your submission?
Thank you, Your Honour. That's very kind. Now that Mr. Al-Khalajli has been joined, as I understand it, my learned friend, Mr. Bowden, will file an acknowledgement of service on his behalf, and his firm, I understand, will come on the record. And an undertaking. I'm grateful. Thank you very much. All right. As Your Honours will have seen, there are really 4 issues for today. They all arise out of the judgment that the court gave on the 8th of September, in which it dismissed Vegie Bar's appeal and confirmed the judgment of the Deputy Chief Justice below when he gave...
Before you proceed on,
yes.
If Mr. Akalaje is going to be joined in as a third party, shouldn't he be listening to your submission?
He's represented. He's represented by Mr. Bowden.
Yes, sir, and indeed he's had a link sent to him, and I'm anticipating that he is joined or will join.
So we can continue with the arguments today.
Yes, indeed, sir. We're here.
Record, you have no objection. You are representing Mr. Akalaje, and
yes.
You say, okay then. Yes, please proceed.
All agreed in advance, sir. Yes.
Okay, thank you.
But it's an important point, Chief Justice, because the last point that I was going to get to is the non-party costs order. And as Your Honour will have seen, part of my application is that Mr. Al-Khalajli should be responsible for the costs of these proceedings. And in that context, it is important that he is given an opportunity to be heard. And so the parties were constructive in trying to make sure that we didn't have to have 2 hearings. And so it's been helpful that we can deal with all of the cost issues that there are between all of the parties today. As I say, that there are 4 issues for today. One of them is agreed. The first issue is the question of the basis for costs of the appeal, the basis for assessment of those costs. So my own friend does not resist an order that Vegie Bar should pay Emirates costs of the appeal. The question is, should those costs be on the standard basis or on the indemnity basis? That's the first issue. The next issue is that I apply on behalf of Emirates for a payment on account of costs. I apply both in relation to the cost of the appeal and in relation to the costs below. And on that, my learned friend's position is, firstly, this court should only deal with a payment on account of the costs of the appeal. And secondly, we have a difference about the proportion of my client's costs which ought to be ordered on account. I say 75%, he says 50%. The third order that I seek, and this is the one that's agreed, relates to some money that is held in court, about $86,000 as security for costs. And as Your Honours will see, that is far eclipsed by the actual costs that have been incurred in these proceedings. So my client seeks payment out of those costs, and that is agreed. That's the third issue, and it's not an issue, subject to your confirmation. And then the final issue, which is the one where there is likely to be most debate, is in relation to the non-party costs order. And as I say, my client Emirates seeks to make Mr. Al-Khalajli responsible for the costs of Vegie in these proceedings. And again, there are two parts to that. The first is the question of principle. Should Mr. Al-Khalajli be responsible for Emirates costs? And the second part is, assuming that you accept that in relation to the costs of the appeal, would you also make the similar order in relation to the cost of the case? And I'll deal with all of those quite quickly. I know you've read the material. There's fairly extensive submissions. I don't propose to go through them in huge detail, but I do think it's important to draw your Honour's attention to a few aspects of this case and also take you to one or two, but not all, of the relevant authorities. Your Honour should have a bundle M, which consolidates together most of the material that's relevant to these aspects of the appeal, and I'll mostly be dealing in that. But I hopefully, if you've read if you had a chance to read the written submissions, we can move through this relatively quickly. So the first issue I was going to deal with then is the indemnity, the basis of costs. Should it be an indemnity cost order? Should it be a standard basis? And the court will be familiar with the test for indemnity costs, but it is now supplemented in the Practice Direction number 5 of 2014. If you have bundle M, I can take you very briefly to that. You will find it behind tab 11. It's the beginning of tab 11 on page M2775. It's the first page of tab 11 of that document, and you'll see the rule which gives you power to grant costs on an indemnity basis is Rule 3817, and then it's supplemented by the Practice Direction, and you will see there little Roman numeral 1 and 2 are the bits that I rely on. Firstly, circumstances where the facts of the case or the conduct of the paying party, that's Vegie bar at this stage, are or is such as to take the situation away from the norm. For example, where the court has found deliberate misconduct in breach of direction of the court or unreasonable conduct to a high degree in connection with the litigation, and subclause 2, or otherwise inappropriate conduct in its wider sense in relation to a paying party's pre-litigation dealings with the receiving party or in relation to the commencement or conduct of the litigation itself. So you're looking for unreasonable or inappropriate conduct. Now, this particular part of the rules is based very firmly in the English case law, which developed the test for indemnity costs. And so I was going to show you very briefly a passage from a case called the Balmoral Group, which is in the same tab of the same bundle, but you need to go down to page 2803, please. And you can see at paragraph 1 there, the test, the basic rule is that a successful party is entitled to costs on the standard basis. This is paragraph 1, and then it refers to the Three Rivers case and talks and says that the factors summarized there. The discretion is a wide one to be determined in the light of all the circumstances of the case. To award costs against an unsuccessful party on an indemnity basis is a departure from the norm. There must therefore be something, whether it's in the conduct of the claimant or the circumstances of the case, which takes the case outside the norm. But this bit's important because sometimes people say the test is a very high one, and it's not, because the court goes on to say it's not necessary that the claimant should be guilty of dishonesty or moral blame. Unreasonableness in the conduct of the proceedings and the raising of particular allegations or in the manner of raising them may suffice. So may the pursuit of a speculative claim involving a high risk of failure or the making of allegations of dishonesty that turn out to be misconceived or the conduct of an extensive publicity campaign designed to drive the other party to settlement. And then it goes on to mention, as you can see, grossly exaggerated claims too. Now, So the nature of the allegations that are being made is important, and the most important, most serious kind of allegations, of course, that one can make against another party are allegations of fraud. And for those sorts of allegations, the position is that where you make a claim for fraud and you fail, the starting point is normally that you have to pay costs on the indemnity basis. And we see that in a case called Natixis. I hope that you will also have tab 12 of this bundle. Sorry, it's 13 of this bundle. This was inserted late. There was a copy of Natixis in there, but it was the wrong judgment, I'm afraid. So if you have the Natixis case and you go down to paragraph 49, which is page 3003 of the bundle, you'll see it said, because it's accepted by Mr. Weeks, that because of cases such as Clutterbuck, the starting point at least is that if you make a fraud claim and pursue it and then either withdraw it or lose at trial, the starting point is that an order for indemnity costs is the appropriate order. And then goes on to say that the court retains complete discretion. So those are the broad principles which I'm asking Your Honours to apply, and then I'll pick out. I'll show you some of the factors of this case, which I say bring you very firmly in these proceedings into the realms of making an indemnity costs order. And the first is really starting off where I finished with the principles, which is the nature of the allegations that were raised in this case. And this is in a number of different parts, because the most obvious fact here is that the claim against Emirates was put in fraud. Now, in part, it was put in terms of, quotes, equitable fraud. So, in other words, using somebody else's property, which you have control over. And sometimes it said, oh, well, that's not quite an allegation of dishonesty, and it's not so serious. It's obviously still very serious conduct. It's an allegation of fraud against a party. However, you may also recall that in these proceedings, Vegie Bar sought to introduce into the appeal allegations of actual fraud, of lies and dishonesty against Emirates. So you may recall that after permission to appeal was granted, Vegie Bar sought to introduce allegations that the bank had lied to the registrar of real property. And I can show you those very quickly if you've got bundle B to hand and you go there to tab 15 of that bundle and page 289.
Which page was that again?
Page 289, 289, please, Chief Justice. Thank you. And there are many examples of this, but this is the heart of the case that was sought to be introduced on appeal. And you'll see that the attempt to amend the pleading was made at that stage. In paragraph 77 and 78, you see the gravity of the allegations that were being raised in a public forum against Emirates. Paragraph 77, the further lease was removed or excluded from the register because the first defendant informed the registrar of real property from November 2012 that units 17A and 17B were not subject to a lease. So you'll recall the issue was whether or not the lease was carried over when the property was sold from Union Properties to Emirates. And what Vegie Bar is saying here is that the reason that the lease their case was that the lease was placed on the register and then removed, and the reason they say is because the first defendant told the registrar that the property was not subject to a lease. And paragraph 78, that advice was fraudulent because the first defendant A, knew that the claimant held a lease for the leased units, and B, advised the registrar that there was no lease, knowing that that was wrong, and on the 31st of August 2014 manipulated the master spreadsheet that recorded the lease of the subject units by the deleting or hiding rows 20 and 21, which recorded that units 17A and 17B were leased, and forwarding the same to the DIFC Registrar of Real Property as a proper record of the first defendant's leased units in Limestone House. So the allegation of fraud was that my client lied to the public body responsible for recording the property interests in an attempt to cheat the claimant out of the lease. And Mr. Al-Khalejli gave evidence in those terms. And so in his witness evidence, and unless you'd like to see it, I won't take you to it, he himself personally said in terms that Emirates lied deliberately to get out of the lease. The reference is page 1462. And also that Emirates tried to cheat Vegie out of the lease. That was his word. And that's bundle E, page 1560. So very serious allegations of fraud were made against my client throughout the proceedings, but also in the appeal. They weren't just made against my client. The allegations were spread around. Your Honours may recall an exchange during the hearing in relation to Ms. Fernandez. And rather quickly, the appellant Vegie withdrew the allegation of wrongdoing against Ms. Fernandez. But the allegation wasn't just brought up in the hearing. There was a campaign directed at Ms. Fernandez herself. And just to give you a flavour of it, if we stay in bundle B and go to page 267, we can see what was said about her in the application for permission to appeal, where she was said to have orchestrated the frauds. So at the top, I'm afraid we seem to have lost one of the pages, but yeah. So I'm afraid it doesn't quite follow through over from the page before. It may be that something's been missed out, but you can see the sense of it from the first subparagraph on page 267. You can see it's being said about her. Ms. Fernandez signed the lease registration form, provided the notice of atonement, receipted the rent, orchestrated the frauds, and was incredibly given the responsibility of searching her own emails, the key documents of which are missing. She is the witness whom Emirates have refused to present, and so on and so forth. So there was serious allegations made against her that she was pulling the strings of some great conspiracy. And elsewhere in these documents, she was described as, quotes, the main actor in these proceedings, and that's at paragraph 104, bundle B, tab 11, page 190. You also see here allegations, the sort of tip of the iceberg, really, of the allegations that were made against both Ms. Fernandez and Emirates of suppression of evidence. So not only was the claim based in fraud, the allegation was that my client and Ms. Fernandez were suppressing evidence to this court, suppressing evidence to the court below, and so therefore effectively lying to this court, for example, when they signed document production statements saying searches had been carried out and no documents had been produced. So my client had been ordered to give standard disclosure, and it was said that the master sales agreement existed, that my client knew it existed, and nevertheless it had signed document production statements saying nothing of that sort existed when they knew that it did. Now that was a particular, not only is that a very serious allegation to make against anybody really, but it was also a particularly costly feature of this claim, because as I've said, heavy disclosure obligations were imposed on my client, which cost a lot of money to comply with. And then there were serial allegations during the course of the proceedings that certain aspects of that were inadequate, that documents were being suppressed, requiring iterative processes of document production and repeated searches. But generally, this is illustrative of a general tendency to be completely relentless in the pursuit of this claim. And when faced with information which should have led Vegie to abandon the claim, Instead, what they did was they doubled down and widened out what became a large conspiracy theory to explain away the problems in their own case. And so, for example, when the registrar, and you'll recall one of the major issues was whether or not the lease had been registered in the land registry. And when the registrar explained in quite detailed terms how it was that the lease had never been registered, and gave the answer to part of Vegie Bar's case about why it was that the lease was listed in a spreadsheet and then came out of this spreadsheet, the response of Vegie Bar was that, well, that explanation was, quote, so improbable that it was ultimately abandoned. So there was clear implication that even the registrar was somehow engaged in this cover-up to try and cover everybody's backs. And so even the registrar got caught up in the allegations that Vegie Bar was making. And regrettably, Emirates lawyers also became the targets of an attack. And so Mr. Carnell, who is the partner at Taylor Wessing, who's responsible for these proceedings, was accused of concealing evidence. Now, it's said that I've overstated this, so let's have just have a look at what is actually being said. If you've got, again, bundle M, and turn please to tab 4. Sorry, I don't know if it is there. Sorry. It's page 2697. That's why. Yeah, it is tab 4, page 2697. And you'll see what's said against Mr. Carnell here at paragraphs 67 and 68. And I'm sure Mr. Carnell won't thank me for repeating these, but it is important to see how seriously this was directed at him personally for no good reason. Paragraph 67. We note that Mr. Carnell's witness statement leaned heavily on the assertion that Vegie Bar had not proven that Emirates had purchased the assignment of the lease. The difficulty with that statement is that Emirates, and therefore Mr. Carnell, as he chose to accept the burden of giving evidence on its behalf, was concealing the evidence that would have established otherwise. Mr. Carnell also claimed to have investigated the matter himself and presented the evidence by way of attachments to the statement of defence. And then it goes on to say, well, that evidence was false. And then paragraph 70, this bit is pleaded in mitigation. What says we are willing to accept that Mr. Carnell himself may have been misled, but that is why we sought and obtained the order dated 20 July 2017, that the circumstances which led to the making of his witness statement be explained. The order should be reinstated and the quality and the veracity of Mr. Carnell's evidence considered. So basically what is being said there is, on its face, he's lied. He personally has lied and he's misleading the court. It might be that he's been misled, but we can only find that out if he explains what his instructions were. And so this sort of attempt is made to put a wedge between Mr. Carnell and his client to say, well, he needs to explain what the relationship was and what he was told by his client. Otherwise, you're entitled to infer that he was in on it too. So you've got very serious allegations in the claim, put in a way which spread around allegations to a wide number of people, including some quite serious criticisms being made of the registrar themselves. I would suggest this is about as bad as it gets when it comes to making serious, unsupported allegations in legal proceedings. And that is before you even get to what was said about the judge. Now, in relation to the judge below, he was accused of bias. Now, in his skeleton argument for today, my friend says, well, actually, all that was ever said was that the judge did not listen. That is simply not the case. And again, we need to look at what was actually said. If you turn in the same, if you go, I'm afraid, to bundle B and find tab 9, page 148, And on page 148, you will see paragraphs 29 and 30. And what I might do is just allow you to read that.
Yeah.
So you see the judge is being roundly assaulted for his conduct of the hearing below. His judgment is said to be disorganized and chaotic. The conclusions are said to be so unreasonable that nobody could really believe in them. And there is an allegation that he deliberately overlooked facts. That's important. That is an allegation of actual bias. Deliberately overlooked facts. So he knew that these facts were material and he ignored them deliberately. And it's clear that the allegation being made against him of one actual bias, at least in the alternative. If you go down in the same bundle to page 160, it's the same document, you'll see at paragraph 58, the conclusion, bias, the judge on an overall analysis demonstrated apparent or actual bias, which prevents him from making an objective determination of the matters before him. It's put in the alternative, but it's made clear that there is an allegation of actual bias, which is obviously an extremely serious allegation, and one which really ought to be marked in costs. I would suggest it's hard to imagine what sort of conduct would justify indemnity costs, if not this one. Now, Vegie says in its written submissions that there is a rule, in effect, that if you get permission to appeal, there can't be an indemnity costs order against you.
Wrong.
There isn't, we'll wait to hear what Mr. Bowden's submissions are in relation to that, but there isn't any rule to that effect. He relies on a Karafi decision, which was quite a specific scenario where an appeal had been reopened. And it appears that the judge who was giving judgment at first instance had indicated he didn't necessarily agree with that decision of the Court of Appeal. But when dealing with costs, his conclusion was, well, because the Court of Appeal has given permission, it's signalled that it thinks slightly differently about the prospects of those issues, and therefore I need to take that into account when I consider the appropriate costs orders in relation to those issues. Now here, the position was completely different because, of course, this court isn't bound by the conclusions of any other court as to the reasonableness or otherwise of bringing any particular allegation. This court has taken a view on the merits of the appeal itself and should apply that view. And in the other point that's important to raise here is that permission to appeal in this case was granted not because there was a real prospect of success, but because the judge felt there was some other compelling reason to grant permission. We don't know what that compelling reason was, but I would suggest that given there was this overwhelming assault on the integrity of the judge and the process that took place below, it is not out with the realms of possibility that he just simply felt compelled to give permission, because otherwise he would be being a judge in his own cause. But if you get permission on the basis of allegations which, on any view, are scandalous, you must know that there will be a price if they turn out to be made without foundation. And your honours will recall that by the time of the appeal itself, there was no mention whatsoever, in particular of the bias allegations against the judge. And the other point, as I've already mentioned, is that even if it was right that giving permission somehow gives immunity from indemnity costs, the actual allegations of actual fraud were sought to be introduced after permission was given. And even if this point was also right, it couldn't excuse the manner in which the allegations were advanced in any event. So the conclusion of all of that, I say, is that it is right that in this case this court should grant an order for costs on the indemnity basis and mark its disapproval of these sorts of unfounded allegations, which, as I say, have been rather scattered about in a scattergun way. If anyone has had any questions in relation to the basis of assessment, that's all I was going to say about that. And then I was going to move on to the next issue, which is the question of costs on account.
Yes.
And as I've mentioned, there are two sub-issues here. One is whether or not this court should make an order for costs on account of the costs below, and the second part is what proportion. So I think it's accepted that this court should make an order for costs on account of the appeal. The only issues are whether that also should apply to the costs below and what proportion. Vegie was ordered to pay Emirates costs below of the claim, and as I say, it doesn't resist the cost of appeal in principle. But after the costs order was made below, all issues of costs were stayed pending this appeal. So my client hasn't yet, or hadn't until the judgment, had an opportunity to approach the judge below for an interim payment on account of costs of the claim. And that's as your honours will know, the ordinary approach of the court is to give parties costs on account of a proportion pending assessment, and the aim is usually to pitch the amount at being an amount that won't be more than is likely to be granted on assessment. Now, I say in the current particular circumstances of this case, that approach should change slightly, and I'll come on to that. But the first issue, as I say, is whether or not this court should also make an order in relation to the costs below. This court has jurisdiction to deal with all costs of the proceedings, and so can make an order in relation to the costs below. I don't think there's any dispute about that, and the relevant rule is Rule 44.108, and the commentary to that rule suggests that when the court is deciding whether or not to remit an issue to the court below or just decide it on its own, the suggestion that's made is that it's plainly preferable, in the interest of saving costs and time, that the Court of Appeal deal with an issue rather than remit it. So the decision for your honours on this issue is really a practical one. Is there anything to be gained by remitting this issue to the judge below? Now, it's more than a year now since the judgment below was issued. And this court, even though your honours gave your decision in September, this court is far closer to the issues and the facts of this case than the Deputy Chief Justice below. And if we have to go back to the judge below, it will simply add another layer of cost to these proceedings. And those are costs which it appears Emirates is unlikely ultimately to recover, at least in full. Why do I say that? We know that Vegie has no money at all, and indeed is likely to be struck off the register in a couple of weeks' time, because it was given 3 months when it was restored to the register to pay certain fines, certain fees, and to show that it has a lease. And as far as we can see, it's very unlikely that it's going to go to the trouble and expense of getting a lease, of paying those fines. And so there will be no Vegie by February. We don't know about Mr. Al-Khalajli's means. Some evidence has been given that he's certainly been supporting these proceedings financially, but the suggestion at one stage was that he was making small payments in instalments, and it may be that he's not a man of huge means. We don't know. He's resident outside the jurisdiction. We don't know where he is. There may be a battle to recover anything. And so I think Vegie accepts the principle that there should, at least in the Court of Appeal, be an order for an interim payment on account. And if that is accepted on appeal, why should that be any different below? It shouldn't. The rule is clear. So what is the purpose of remitting that issue to the Court of First Instance? And the only thing that will be achieved is delay and presumably, from Vegie Bar's perspective, the hope that Emirates won't spend the money to make the application below. So in my submission, this court has the power to make an order for an interim payment in relation to the costs below, and of course those costs have already been ordered. That is an order that would routinely be made. Vegie Bar accepts the principle. It just says it doesn't particularly want you to make that order in relation to the costs below. My suggestion is that Your Honours should make that order and should make it in not just in relation to the Court of Appeal, but for the costs below. On this question, Your Honours may recall that Mr. Al-Khalajle made an application to this court to restore Vegie Bar to the Registry of Companies. And it made that application. When it did make that application, Your Honours noted in your judgment, and it's paragraph 23 of your judgment, that this court was willing to overlook what it described as the procedural irregularity of an application to this court and take a pragmatic approach in that instance. Now, I say there's no true irregularity here. My client was unable to make the application below because the cost issues were all stayed until the judgment of the Court of Appeal came out. But we would ask the courts to take a similarly pragmatic approach to this issue. And if it does so, then I say that it ought to make an order in relation to the costs below. The other part then of the issue of costs on account is the proportion of costs that Your Honours should award. And the difference between us is that on that proportion, I seek 75% of the costs incurred. The starting point for the court when they're granting orders on account is a 50% order, and that is what Vegie Bar contends for. But we are seeking a higher proportion really for 4 reasons, and I'll give you those now. The first reason is that it turns very much on the submissions I made at the outset. If indemnity costs are ordered, the result is likely to be, or very likely to be, that a higher proportion of the costs claimed will be awarded. And allied to that is the second point, which is that all of the conduct on which we rely for an order for indemnity costs will also justify a higher proportion of the costs being claimed. And this is in part because of the gravity of the allegations, in part because of what I describe as the relentless and shifting nature of the way that the claim was conducted. The effect of that was to drive up costs. Particularly, that was particularly true in relation to the costs below. As I say, substantial sums had to be spent on dealing with these allegations that documents were being suppressed and requiring full-scale disclosure processes and lengthy and expensive searches about which there was evidence before you below. The third point is the nature of the allegations that were being advanced. Because of the gravity of the allegations and the allegations of fraud, it meant that my client simply had to spend the money to defend the case. It couldn't risk an adverse finding, and what that meant was that it had to instruct senior lawyers to represent it and wade into the morass of detailed allegations and deal with that detail. The other point there is that because of the way that the claim was presented, we were never given a number. All that was said was this is going to cost millions and millions and millions, And you may recall, ultimately, it was very difficult to see how there could have been any value in the case. So the result of that was that there was simply no scope for buying this claim off. There was no scope for settlement. And then the final point is that the prospect of a full assessment is very low, because Vegie Bar is insolvent, and it looks like it will be struck off the register again in February. Mr. Al-Khalajli may or may not have the money. Emirates may or may not be able to enforce against him, even if we get a third-party debt order. But either way, it is unlikely to be cost-effective to litigate through an assessment. I don't have instructions as to whether that will be pursued, but the reality of this is that it's unlikely to be cost-effective to do that. And so the order that you make now may, in practical terms, be the assessment, if I can put it like that. And as I've said, the ordinary approach is to try to strike a balance to ensure that the party receiving is not overpaid before the assessment takes place. So what I say is that in the circumstances of this case, it would be reasonable to adjust that approach slightly and try to shoot for a more accurate figure in the circumstances. So that is why I'm seeking 75% of the costs of the appeal and of the costs below. You now have the cost schedules. I won't take you to them. It's not a detailed assessment process, but just they should be summarised somewhere. But just to tell you what they are, the Court of Appeal costs you'll find at M2714, and those are 630,000 dirham. The application costs today need to be added, and that's another 294,000 dirham. And then the first instance costs are 1,841,000 dirham thereabouts. So you get a total of about 2.75 million dirham. And what I'm looking for is 75% of that, which comes in at around 2 million dirham. So it's a little bit over $500,000. It's $540,000 or thereabouts for the whole of the proceedings, all of the appeal and this application. And I would suggest that even when it comes to assessment, given the drip feed nature of the way in which these proceedings have progressed and the seriousness of the allegations, it is in any event very unlikely that on assessment my client would receive much less than $540,000 or around the 2 million dirham mark. So that's the second order that we seek in these proceedings, in this application. As I've said, the third part of the application is in relation to payment out. That is agreed. The sums in court, I don't have the precise figure for you, I'm afraid. I think it's $86,000 that was ordered to be paid as security. And as you can tell from the numbers that I've been telling you about, that has turned out to be well below the costs that were actually incurred. But there is no dispute that whatever is ordered by way of immediate payment on account, the first part of it will be paid by withdrawing that money from court. So then the final issue for you today is the question of non-party costs. And so this is an order that I seek that Mr. Al-Khalajli be responsible, be liable to meet these costs orders as well, and not just Vegie Bar, because we know that Vegie Bar is insolvent. Vegie Bar has said that it has no money. And absent this sort of order, nobody is going to inject any capital into this company because its sole asset was the lease and this claim. When you come to decide this issue, the parties agree pretty much entirely on the principles, because everybody agrees that the leading case is a case called DIFC. It's a decision of the Privy Council in the United Kingdom, and it's an important case. I think it is worth looking at this case briefly. I'll take you to 2 or 3 passages in it, because once the court has in mind the test, it's, I would suggest, fairly clear that that test is satisfied. And so the case itself you'll find in bundle M, and it starts at page 2778, and the place I'd like to take you to is page 2784, please, in paragraph 20. I should just note that you'll see, if you read the full case, that there was also in that decision, there was an issue about the court's jurisdiction, which doesn't arise in this case. But the other factors which were considered were, firstly, whether causation was established, and I'll explain what's meant by that, and then went on to deal with discretion. So at paragraph 20, the court is dealing with causation, and you can see the sense in which they're dealing with causation. Paragraph 20, you'll see in the middle of that paragraph, a non-party could not ordinarily be made liable for costs if those costs would in any event have been incurred, even without such non-party's involvement in proceedings. So that is what is meant by causation. The non-party must cause the costs to be incurred. And then if you go down in the same decision on the same page, you'll see at paragraph 25, the test is outlined, and in particular at little 1 on the third line, you see the Privy Council here says, although cost orders against non-parties are to be regarded as exceptional, exceptional in this context means no more than outside the ordinary run of cases where the parties pursue or defend claims for their own benefit and at their own expense. The ultimate question in any such exceptional case is whether in all the circumstances it is just to make the order, and then recognises it's a fact-specific jurisdiction. You'll see then there's talk about pure funders, but then if you go down to paragraph little 3, which is about a little over halfway down that paragraph, where, however, the non-party not merely funds the proceedings, but substantially also controls, or at any rate is to benefit from them, justice will ordinarily require that if the proceedings fail, he will pay the successful party's costs. The non-party in these cases is not so much facilitating access to justice by the party funded as himself gaining access to justice for his own purposes. He himself is the real party to the litigation, a concept repeatedly invoked throughout the jurisprudence. So the court is looking at whether or not the third party caused the company to pursue the claim. That's the causation bit. It's about the degree of control that the third party exerts over the proceedings, whether he stands to benefit substantially from it, and also whether the company is likely to be able to pay, and whether bringing the claim was reasonable. You can see that in the quote on page 2785 in the middle. You'll see there's a quotation on that page, and just to speed it up, about 2/3 of the way down, you can see reference to the degree of possible benefit to the non-party, and whether in all the circumstances the bringing or defending of the claim, although in the end unsuccessful, was a reasonable course to adopt. The other part of this judgment which is worth looking at is just the very next paragraph, which is paragraph 26, which cites with approval a New Zealand case, and you'll see paragraph 19. Guiding principle here is that the cost orders against third parties are exceptional, but that they are warranted in cases where there would otherwise be a situation in which a person could fund litigation in order to pursue his or her own interests and without risk to himself or herself should the proceedings fail or be discontinued. Paragraph 20, where a person is a major shareholder and dominant director in a company which brings proceedings, that alone will not justify a third-party cost order. Something additional is normally warranted as a matter of discretion. The critical element will often be a fresh injection of capital for the known purpose of funding litigation. In paragraph 21, the overall rationale is that it is wrong to allow someone to fund litigation in the hope of gaining a benefit without a corresponding risk that the person will share in the cost of the proceedings if they ultimately fail. So that is the case which guides the application of your discretion. Everybody agrees that that is the case, and you see there the test. I should point out that this is not about piercing the corporate veil, because if you could pierce the corporate veil, then there would be a legal liability on the director. And so the fact that it's a discretion, which shows you that the court can look at what's been described as the economic realities. You're not fettered by the legal realities. And I cite in my skeleton argument, if you've had a chance to look at it, a short passage from the Axel Frelfall case, which makes that clear. So it's not about meeting the test for piercing the corporate veil. It's about a discretion to make another party who would not otherwise be liable responsible for costs. Now, in this case, in my submission, it's very clear that all of the factors that have been identified in this authority support the making of an order. Mr. Al-Khalajli was clearly in control of this litigation. He was running it all the way through, and you will have seen, I think in the end, he produced 11 witness statements in support of this. He very clearly took ownership of the allegations that were being made and made them himself. He pursued these proceedings for his own ultimate financial interest. It was in the name of the company, of course, but we know that he is a co-shareholder. There is one other shareholder, but we know nothing about that person, and we've seen no reference to them. As I say, Mr. Al-Khalajli provided the evidence, pretty much all of the evidence in support, other than what was provided by his solicitors, and he also accepts that he injected the money, the capital, that was required to pursue the claim. That's all conceded. And even the latest round of submissions made on his behalf emphasise his attitude to the claim. So the lease is described, even in those submissions, still as his lease. He was pursuing his rights, and that's how he characterised it. And that must be right if you're looking at the economic realities. And when it comes to Vegie Bar's ability to pay, absent this sort of order, which we've seen as important, Vegie Bar candidly admits that it's not going to be able to pay any of the money which is ordered. So without this order that I'm seeking, the result would be that Mr. Al-Khalajli would be allowed to pursue a claim, which is on the economic realities his claim, without being liable for the costs. And that is a heads I win, tails you lose approach. And those are exactly the circumstances in which it is right to make an order of this sort. Once again, there is an issue. If you were minded to make that order, there is an issue as to whether or not there should be an order also in respect of the cost below. And that is resisted. So the suggestion appears to be that we would have to have this debate once again in front of the judge below. We'd have to make another application to the judge below and have all of these same issues, because they would be exactly the same issues litigated in front of the Deputy Chief Justice, presumably, or another first instance judge. This court has the jurisdiction to decide all issues about costs. We say it should do so essentially for the same reasons that I mentioned in respect of the issue of interim payment, because if you don't, it will just add another layer of cost. If you decide that an order, a third-party cost order, is appropriate, it is very hard to see how a judge of the first instance court could decide that differently. It may or may not be that, I suspect there would be an issue estoppel, but even if there wasn't an issue estoppel, effectively what the Mr. Al-Khalajli would need to be inviting the judge below to make an effectively inconsistent judgment below. So the right result, we say, must be that Your Honours make the order now, both in relation to the cost of the appeal and also the cost below. And again, Your Honours were willing to adopt a pragmatic approach to Mr. Al-Khalajli's own application to restore his company to the register, and I'd ask you to adopt a similarly pragmatic approach in relation to this issue. Your Honours, unless you have any questions for me, those were going to be my submissions at this stage.
Thank you very much, Mr. Montague Smith.
Thank you.
Any questions from the judges? If there are no questions, then we'll invite Mr. Bowden to reply.
Good morning, sir. Can you now hear me?
Yeah, I can hear you.
Right, thank you very much. I've changed to a different computer. Just dealing, I think, with the points my learned friend has made this morning. Just to confirm, we accept the payment out of the $86,500 US. We accept the payment on account and I'll just clarify this now and apologise if any confusion arose, except that there should also be a payment in the a payment on account in the CFI. The rules set out that it should be, PD 1/2015 at 0.5 sets out that it should be at 50%. However, I appreciate what my learned friend says in relation to indemnity costs, and if indemnity costs follow, I accept the argument that figure should go up, and therefore his 75% would be appropriate. Just in relation to the point about the granting of leave to appeal in Karafi, I accept what my learned friend says about that. There's a recent book which has been published which put it slightly differently, but I accept the explanation that he prefers in relation to that. We've accepted the service of the order, and of course we will accept the service of any consequential orders. And the point about costs below is not to say that Mr. Al-Khalili wouldn't accept any orders in respect of the court below. His consent extends to that. He makes the point that he doesn't believe that whilst costs should be ordered in this court and have been ordered in the court below, he believes that there should be an assessment in the court below, perhaps in front of the registrar, that being the point. He does not accept indemnity costs. He says that it should be, Vegie Bar says that it should be on the standard basis. And we do not accept the order against Mr. Al-Khalili personally. And that really sums up, I hope, the separate approaches to the court. And I'm happy to put that in writing immediately following if that's of any assistance.
Mr. Bowden, I'm sorry that I'm sure it's my fault. I was a little confused.
Sir?
You accepted that if indemnity costs were ordered, there should be the 75% was appropriate. Was that only in relation to the Court of Appeal costs that you were speaking?
Well, I think it follows, sir, whatever order you make. So if you make that order in the court below, I think it should follow there too, sir. So if the order is indemnity costs in this court and the court below, that's an acceptance, sir, that's the 75% should flow through in the same manner.
I did not understand, and again it may be my fault, that the application was for indemnity costs in the court below. I thought it was only indemnity costs in the Court of Appeal. Perhaps we might ask Mr. Montague-Smith to clarify that.
Yes, certainly. You're right. That's right. We've taken the decision not to go back to the judge below or appeal his cost order below in relation to that. He made an order on the standard basis below.
Okay, so back to Mr. Bowden then. Where are you? Would you mind restating your position about payment on account of the costs below? Do you accept there also that there should be an uplift or not?
Well, if there's, and I I apologise, sir. If it's going to be standard costs in the court below, sir, in the absence of indemnity costs, we would say that it should be 50% in the court below.
I understand your question. Thank you.
And thank you for the correction. Now,
Your written submission, Mr. Bowden.
yes,
That's
sir.
all you want to say. Otherwise, you rely your submission on your written submission.
You've seen my written submission, sir.
That's all you're saying.
Well,
You have got nothing else to say. Okay, I just want to be clear that there's nothing else for you to say, nothing more. So I assume, Mr. Montague Smith, you got nothing to reply.
I'm not certain, Chief Justice. I'm sorry. I thought Mr. Bowden had a bit more to say. That's not to encourage him, of course, but.
Well, why do I do this? This is never a happy situation, and it's not one I'm looking to aggravate at this point in time. Clearly, you have read our submissions, and the base submission is that the claimant believed, on what it saw as reasonable grounds, that it had a good case on the stated case going forward, and everything it did really flowed from that. So it was a bona fide claim, sir. I won't go in that case at all to the 18-page written submission which I have put in, unless you have any clarification, seek any clarification in respect of it. But I will respond briefly to the submissions, the skeleton argument of my learned friend, and then go to some of the authorities. And I don't expect to take very long at all. Just in relation, sir, to the issue of, we don't know why the judge granted the leave to appeal. And I note that the same judge has done something similar in another appeal. So I don't think we can really infer anything from that. Now, just moving to the leave to appeal document, and I have marked that if it's helpful to you in the coloured tabs, and the colour would be yellow. And in relation, if you're able to find the yellow tab on your screen, if that's helpful to you, and I've just set out there the passages relating to the amended application for permission to appeal, and that's at B.140. And in respect of that, the point is this, sirs. The decision was not an easy one to understand, and it found, and I'm at B146, Your Honours. The decision found that no lease existed, that it found indeed that the units did not legally exist because they were provisionally registered. It also said because they were provisionally registered, that wasn't registered at all. And it denied that the RORP had said that the reason why it was not registered now was because ENDB had told it that there was no lease. Now, with respect, that's just a snapshot, but it was not an easy decision to understand, and it hasn't really featured since. Again, the key case has been completely rerun before this court, and so to take two words, disorganised and chaotic, out of a lengthy paragraph, and that's at B148. The entire paragraph is set out there. Is with respect not entirely fair. So what the paragraph said at paragraph 29 of the leave to appeal document. It said it's axiomatic that every trial must be fair. The judge failed in his central duty to identify key issues and focus upon them. The judge did not refer to or even consider relevant evidence, and where he did refer to evidence, did not properly deal with the evidence. And with respect, there was a lot of evidence about the payment of rent, the payment of 3 months in advance payment of rent, which we said evidenced the assignment which had taken place. Now, that just didn't feature at all in this decision. And again, when it came to the matter of the lease registration form, where there had been in a 2-day trial, there had been a real focus on that. And again, it simply wasn't discussed. And so we're in a very difficult position. We've lost badly. We've been very much criticised, and I suspect we're going to be criticised a lot more. And so that's how it is. It's not a fun day. But there were points that needed to be made about the judgment, and I'm going to come to something I regret in a moment. But what was also done is that document, the leave to appeal document, was 22 pages long, a number of paragraphs. It did, for better or worse, set out to detail the claims that were made and the points that were made. So these were not sweeping assertions. They were backed up and were below B149 to the points to the grounds of appeal. There were a number of grounds of appeal, each of which was detailed by reference to the evidence saying why. Now, ultimately, those have been found to be wrong. We are bound by this court's decision, and we have to accept it. But all I am saying in relation to that is that there were points to be made. Now, I have already said that, and I can't blame the client for this. I'll take the blame myself. I deeply regret saying that the judge was biased, and I didn't pursue it ultimately. But in my defence, all that was ever said was that the judge did not listen, that he roundly rejected everything, every single thing that we had said, and some of which couldn't be rejected. I have personally apologised to the judge. I've been back before the judge, and he has treated me very fairly, and I'm grateful to him. If it has personal consequences for me, well, I'll have to deal with them. But it is something I sincerely regret. It wasn't necessary to say. It's been found to be incorrect, and I hope I've taken adequate steps. Now, just dealing briefly with Mr. Carnell, and it's set out in some detail in the initial response. Mr. Carnell did what lawyers shouldn't do, and that is make a witness statement, which asserted a number of factual matters on behalf of his client. And with respect to him, a lot of what he initially said was incorrect. And it was incorrect then, and so I'm just going to it's paragraph 30 of our response application. That's starts at page 2720. Now, this was a 19-page letter, okay? It dealt in great detail with lengthy schedules with the document production, and asked a number of questions and sought further document production. Right? And in the context of that very lengthy, very detailed letter, which was measured and polite, it was said in respect of Mr. Carnell's evidence that he had made some assertions. MBD had no knowledge of the Vegie bar lease. Now that's been accepted that they did. That the sale and purchase documents did not disclose the existence of the lease. Well, the surrounding documents most certainly did. that they had not complied with the terms of the lease. Well, they did. They paid rent in advance. They paid the security deposit. They paid the fit-out fee. They attended meetings. They did everything that, as the previous panel of this court said, it appears that Mr. Al-Khalili has done everything, or Vegie has done everything that it is possible to obtain this lease. They were acting bona fide in good faith. And then finally, that Vegie had not paid any consideration for this lease. Now, again, that was incorrect. Now, all that was said to Mr. Carnell is that if lawyers take on the burden of giving evidence on behalf of their client, and factual evidence, that they become bound to that evidence. Furthermore, it was immediately accepted in the very next paragraph, paragraph 70, to the one that my learned friend takes offence to. We are willing to accept that Mr. Carnell himself may have been misled. All he needed to do, and all we were asking him to do, was clarify the position. And that is all. With respect, you have to call these matters as you see it. And personal explanation, I've been doing this job for 30 years, and this is probably the most difficult situation I've ever found myself in. But you have to follow the evidence without fear or favour, and call it as you see it. And we as lawyers, we do have leeway. And I'm not on trial here, I appreciate, but sometimes it feels like I am. You do have to call it as you see it, and that is the benefit and the strength and perhaps the disadvantage of our court system. So all that was said with respect to Mr. Carnell is, this is what you said. These are in fact the facts, and we would ask you to clarify this position because it's wrong. And your client was in possession of information which proved that wrong, and a failure to correct it is a problem. Now, my learned friend's point about all this whole letter would have a lot more force if it was ever answered, but it was never answered. So perhaps we made the strategic error of not going back and trying to fix up the document production, but even from the claimant's point of view, this case had gone on for long enough by that stage, and there was discussion about what happened in 2019, I think, from the Chief Justice and my learned friend at the last hearing. Well, that's what happened in 2019, a long, drawn-out discussion over the adequacy of this document production, and a very, the document production, with respect, wasn't satisfactory. The document production continued right up to the day before trial, when I think we had 75 additional pages of very important material produced. And that's a common problem in court cases. We dealt with it, we took it on board, but it was extremely difficult. All that was ever produced in relation to Miss Melanie Fernandez was a snapshot of the 23 emails that had been culled from her computer. The rest weren't produced. They've never been produced. We were critical that Miss Fernandez was put in charge of searching her own computer. That is correct. And I don't really quibble with my learned friend's factual assertions. My learned friend's rendition of the facts. We did make some serious allegations. They have been proven incorrect, and we will be judged for them. The point is that all of this needs to be seen through a prospective lens, not a retrospective one. And that perhaps comes back to the point that the case where I didn't produce it because of the criticisms of excessive authority, but at paragraph 7 of the earlier submission, I put the decision of Justice Coulson, as he then was, in Elvanite Full Circle Limited v. AMEC Earth and Environmental. And indemnity costs are appropriate where the conduct of the paying party is unreasonable to a high degree. And my learned friend says, well, that has been easily satisfied. But this is the point. Unreasonable in this context does not mean merely wrong or misguided in hindsight. And so this case started on from a lens, and I have taken refuge in the formulation of the previous panel of the Court of Appeal from Sir Jeremy Cook, that what you actually mean is, this is what he said to me in argument, what you actually mean is not buying the underlying units subject to the lease, but actually buying the assignment of the lease. And that was the factual premise which underpinned, factual and legal premise which underpinned the claimant's case. And when that failed, there was a cascade effect through the rest of it. And so whilst the claimant maintained that there was an assignment, and so that everything that happened after that was against that assignment or hiding the evidence of that assignment, the defendant's case, which has come through as the winner, is that there was no assignment, and so nothing that happened after that date was wrong. But if what I'm asking the court to accept is that those were that was the lens of the claimant at the beginning of this case, that there had been a valid assignment and that there had subsequently been a valid registration. And there was, with respect, considerable evidence of the assignment, including, of course, the letter written, and it's at paragraph 12.1 of the earliest Court of Appeal decision, but the letter written from Emirates MBD dated the 25th of December 2011, which said that UP will assign the proceeds of the rent to Emirates MBD, and that from that point onwards the rent will accrue to Emirates MBD. That was the position, and I don't intend to get into it, but there was evidence of the master sales and purchase agreement. And again, simply looking at it from the claimant's point of view, right, there was good evidence in its assessment of it prospectively that established these things were correct. And likewise, with the registration, the lease registration form signed by Emirates, signed by Vegie and signed by the registrar of real property and stamped as by the former as well. And then, so we have the actual registration documents, and that is set out at D.-1309, Exhibit D10, which is the spreadsheets, and not one spreadsheet, but a number of spreadsheets, which set out these leases. And if one goes to it, and I'm not sure we need to, but the Vegie lease was one of the earlier leases registered of the, I think, 80 leases set out in those spreadsheets. Vegie was one of the first ones to record a registered date. So, all I'm saying, we've lost. We're bound by that. I'm not using this as a further tri-level appeal, but there was evidence upon which we could rely. Now, sorry, coming back, I digressed there. That's dealing with Mr. Carnell. And then that's my next point, that if there was an assignment and there was a lease, there seemed to be a clear admission that there was a lease. This is dealing with the letter of the Rorp's letter of September 2018, and with respect to that letter, it did appear that there was a clear admission from Emirates NBD that there was a lease. What they said, I'm sorry, I'll just go to it, was that the lease, this is in relation to the registration and the effect of the lease registration form. And what the Rorp said and I'm sorry, paragraph 21 of my earlier submissions, was that the registration was and the entry into the Excel spreadsheets marked lease registration, kept not by the RORP but by DIFC Registry Services, which is a standalone organisation, was a practical means of keeping a record of a lease having been entered into in the jurisdiction of the DIFC, that a particular entity had entered into a lease for a property in the DIFC, which is generally a prerequisite for the issuing of a trade licence in the DIFC under the DIFC Companies Law. And of course, Vegie got that trade licence. That's not in dispute. So again, prospectively, it looked like a good case. And what Emirates said in paragraph 22 of the December submission, the so-called provisional registration of the lease was simply a system by which a record of leases was kept to allow companies to satisfy the requirement that they have a DIFC lease. Absent some formal record of a DIFC lease, companies would be unable to obtain or renew their trade license. Again, looking prospectively, that appeared to strongly support Vegie Bar's case. As it turned out, it failed on assignment right at the beginning, and that was the end of the case as it was put forward. Now, I simply don't accept, with the greatest respect to my learned friend, that the claimant accused the RORP of any impropriety. But it was said in the earlier Court of Appeal decision that what was meant by provisional registration was unclear. There was a great deal of debate about that. And in the RORP's September letter, he walked back from that position and said that no, there was indeed no provisional registration, and the difficulty was instead that there couldn't be any folios. Now, that didn't work either, and that was a point being made. And Justice Giles has already pointed to extravagant language, and that's correct. There was extravagant language, but it wasn't wrong, and it wasn't accusing the RORP of anything, and that's the only point I wish to make about that. Now, relating to Mr. Al-Khalili and his personal liability for costs, the first point I'd like to make is that he has acted entirely properly in relation to this matter. He could have dived, but he hasn't. He's instructed solicitors, instructed counsel, and we're here today. And so that's his position. I accept that the funding which came in relation to this proceeding, it came from Mr. Al-Khalili. And one could hardly deny in the face of 11 separate witness statements that Mr. Al-Khalili controlled the proceedings. He did, but not for his personal benefit. The reality is that he was the driving force behind the company. His 10th witness statement indicated that he had employed a substantial number of staff, obtained licenses, franchise agreements, gone and obtained a lease for the premises he was going to operate from, and at all times he was in pursuit of the goals of the business, and that's the key differential. Yes, he funded it because he was the general manager. Yes, he was highly invested in the success of the business, and yes, he controlled and funded the proceedings. All of those are against him. But what is not against him is the fact that everything he did is that his interests were entirely ad item with the companies. And proof of that, I say, is that the claim that he was seeking was specific performance. So he didn't sit back and say, okay, I've been better word, for want of a better word, I've been cheated out of my lease, And so therefore I'm going to make all these allegations, and I'm going to pick up a big award of damages, and I will take that because I am the alter ego of the company. He, at all times, and the evidence is very clear, right to the very end, he pursued the objectives of the company. Now, if I can just go to the cases upon which my learned friend has referred, and I have them, and I'm hoping this is available to you. I have tagged them in red. The first one that I would wish to go to is DIMICS at paragraph 28, and that is at page M.-2786. And on, if you're seeing it on the screen, I've highlighted the box in orange, and whether it's helpful or not, have actually highlighted within the box, and it says this: an order may be made in a wide variety of circumstances where the third party is considered to be the real party interested in the outcome of the suit. It is not, however, sufficient to render a director liable for costs that he was a director of the company and caused it to bring or defend fund proceedings which he funded and ultimately failed. So that's my submission, is that my learned friend's case fails on the facts. That there's no evidence that he went any further than causing to bring or defend proceedings which he funded and which ultimately failed. And with respect, the fact that the proceedings were conducted in a good way or a bad way shouldn't impinge upon that reasoning. Where such proceedings are brought bona fide, and this is the next point, I'm still at paragraph 28, which is in fact, I should say, sorry, a reference to Lord Millett. It's quoting Lord Millett in Metal Alloy Supplies. But where such proceedings are brought bona fide and for the benefit of the company is the real plaintiff. In such a case, an order could be made against a director in the absence of some unproprietary or bad faith on his part. If in such a case an order for costs could be made against a director in the absence of some impropriety or bad faith on his part, the doctrine of separate liability of the company would be eroded, and the principle that such orders should be exceptional would be nullified. And then it goes on to deal with the position of a liquidator. But at paragraph 29 of DIMICS, it says this, and this is the actual decision, this speech of the House of Lords. In light of these authorities, their lordship would hold that, generally speaking, where a non-party promotes and funds proceedings by an insolvent company solely or substantially for his own financial benefit, and this is really the key to it, he should be liable for the costs if his claim or defence fails. As explained in the cases, however, that is not to say that orders will be invariably made in such cases, particularly, say, where the non-party is himself a director or liquidator who can be realistically regarded as acting in the interests of the company, brackets, and more especially its shareholders and creditors, than his own interests. So whilst there's obviously a coincidence of interest between Mr. Al-Khalili and the company, because he's a shareholder and he's a manager and he was intending to run, operate, manage the restaurant, his interests are those of the company, and what he was promoting from the beginning to the end were the interests of the company. Now, then if we could just turn to Goodwood at paragraph 47, and this is on page M.-2796. And again, this is quoting an earlier case, Taylor and Pace, Developments, 1991 BCC 406. 47. The controlling director of a one-man company is inevitably the person who causes the cost to be incurred, in one sense, by causing the company to defend the proceedings. But it could not be right that in every such case he should be made personally liable for the costs, even if he knows that the company will not be able to meet the plaintiff's costs. Should the company prove unsuccessful, that would be far too great an inroad on the principle of limited liability. I do not say that there may not be cases where a director may not properly be liable for costs. Thus, he might be made liable if the company's defence is not bona fide. For example, where the company has been advised that there's no defence and the proceedings are defended out of spite or for the sole purpose of causing the plaintiffs to incur irrecoverable costs. No doubt there will be other cases, but such cases must necessarily be rare. In the great majority of cases, the directors of an insolvent company which defend proceedings, there's a difference there, brought against it, should not be at personal risk of costs. So, with respect, if the court accepts that seen through the lens of the prospective lens, that this looked like a good case, and with respect, I lean heavily upon the previous decision of the previous panels of the Court of Appeal and the two decisions which emanated there, both of which were supportive of the claim. And at paragraph 14.1 of the decision of the 24th of January 2018, it was said that the case, when it returned, because there was a return date, was stronger, but that it hadn't got to the very high standard to resist the payment of an order for security for costs. But it was certainly recognised that there was a good case there. And then if I can next move to paragraph 49 of Goodwood, such an order is, however, exceptional, since it's rarely, it may be made in a wide variety of circumstances where the third party is considered to be the real party interested in the outcome of the suit. It's not, however, sufficient to render a director liable for costs that he was the director of the company and caused it to bring or defend proceedings which he funded and which ultimately failed. Where such proceedings are brought bona fide and for the benefit of the company is the real plaintiff. If in such a case an order for costs could be made against a director in the absence of some impropriety or bad faith on his part, the doctrine of separate liability of the company would be eroded, and the principle that such orders should be exceptional would be nullified. The position, and then it goes on to deal with the position of the liquidator. So, with respect, even if the order is one for the imposition of indemnity costs, notwithstanding that, the position arises that should Mr. Al-Khalili be liable as a third party for those costs. And of course, we've got the position where different situations arise in the Court of Appeal and the court below. And so even if one says, well, the bona fide part attaches not to the decision to bring the proceedings, but to the decisions made within the proceedings and the conduct of the proceedings, which is, I'm assuming, what my learned friend would say. But even in that case, Mr. Al-Khalili should only be liable for the Court of Appeal costs. But in my respectful submission, what these cases are saying is that the bona fides relates to the decision to bring the proceedings. So was it brought on a bona fide basis? And if it was conducted badly, for one reason or the other, that does not impose the obligation for third-party costs. Now, moving on, the next point is still on Goodwood, and that's in paragraph 51, page M.2797, where it talks about the access to justice. I'm sorry. There it is, paragraph 54. And it's, unfortunately, it circles back to the Privy Council and DIMICs, but it suited the manner in which I was wishing to address these points. So I've addressed it here rather than through the DIMICs decision. The Privy Council and DIMICs has now reviewed the whole of this field in detail. The judgment of their lordships was delivered by Lord Brown of Eton under Hayward, he said. And then I have, we are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 lines down, halfway along the paragraph. And in the original decision, it's actually a separate paragraph. But in their case, the court's normal approach is to give priority to the public interest in the funded party getting access to justice over that of the unsuccessful unfunded party recovering his costs, and so not having to bear the expense of vindicating his rights. However, the non-party not merely funds a proceeding, but substantially also controls, or at any rate is to benefit from them, justice will ordinarily require that if the proceedings fail, he will pay the successful party's costs. The non-party in these cases is not so much facilitating access to justice by the party funded, as himself gaining access to justice for his own purposes. He is the real party to the litigation, a concept repeatedly invoked throughout the jurisprudence. But the point to be, or the thread of authority to be drawn from this in my respectful submission, is that the claimant, if he was acting bona fide still for the interests of the company and not simply for himself, so there's a cumulative requirement: A, that he funded it, which is tick; B, that he controlled it, again tick; and C, for his own interests, which is not accepted. If that is the finding of the court, the access to justice provisions is set out in paragraph 25 of DIMICs and at 54 of Goodwood, and reproduced at paragraph 54 of Goodwood, are appropriate, and that should be taken into account. And that is particularly so. There is no provision in this court for legal aid. There is no provision, or no longer any provision in this court, it appears, for the deferment of fees. And Mr. Al-Khalili did put his hand in his pocket, and he did pay the $86,000. And when he paid that $86,000 as security for costs, he might reasonably have believed that that would be all that he would be required to pay. And if there was a legal aid provision available in this court, he would have protection against costs. But there's not. And so if access to justice is a prevailing feature, to be a prevailing feature of this court, it is unfortunately the case that impecunious claimants will cost defendants who have deep pockets money. but that is a feature of the justice system, and it really comes down to, did he bring a bona fide claim? And then I was going to deal with Karafi paragraph 55, but I've already dealt with it. So I haven't referenced my supplementary submissions directly, but a lot of what I have, I think, just said orally is set out in those supplementary submissions. And unless there's anything else, Your Honours, those are the submissions for the claimant in relation to these applications.
Thank you very much, Mr. Bowden.
There is one thing I would like to clarify, if I may, Mr. Burden. What's your current position on whether this court, the Court of Appeal, can deal with the question of costs on account of the CFI costs?
Yes, sir. I listened to what my learned friend said about that, and we too are after a practical solution, and so I accept what my learned friend submitted in relation to cost on account, albeit that indemnity is not sought in the court below, and so therefore it should be 50%. But yes, in principle, yes, sir.
And the same as to non-party costs. In other words, if we decide that a non-party cost order is appropriate, is your current position that there's nothing to stop us, if we see fit, saying there should be a non-party costs order in relation to the CFI costs as well?
Yes, sir, because as my learned friend pointed out, issue estoppel or not, he would undoubtedly succeed in such an application, and there's not much point in getting in the way of it. And we've said that we will be cooperative, and we have.
Yes, it does seem a very, would be a rather silly thing to be otherwise. So thank you very much for that.
Okay. Mr. Montague Smith, you want to say something? Reply?
May I just come back very briefly on a few issues, and I'll be as quick as I can. I'm grateful for the indication to my learned friend about the further concessions that have been made. I just point out in relation to percentages, I don't base my 75% figure purely in a finding of indemnity costs. Indemnity costs is really just a question of burden of proof. So it's still a question of recovering reasonable costs. The costs always have to be reasonable. It's just about where is the benefit of the doubt, where the court goes through that assessment. In relation to indemnity costs, I'm a bit surprised by my learned friend's submissions in relation to both Mr. Carnell and Ms. Fernandez. I think the key point in relation to Mr. Carnell is that it was always clearly understood that he was setting out his client's case in relation to the existence of the lease and what they knew about the lease. But the way in which my learned friend dealt with the issues of Mr. Carnell and Ms. Fernandez really illustrates some of the problems that we have had dealing with this case. So, for example, my learned friend said it was accepted that Emirates had knowledge of the lease at the time they bought the property. That was never accepted. It was accepted for the purposes of the application for immediate judgment, that there was evidence from which that could be inferred. That evidence was that reference to the lease was made in a spreadsheet, which was attached to an email that was sent to Ms. Fernandez. Now, my client's position was it never put two and two together and recognised that there was in fact a lease. So my learned friend presents his client's position as if there is an agreed statement of fact, and then I have to trouble you and then the court and take the time to unpick all of that to show you that in fact that is not ever the position. In relation to Ms. Fernandez as well, there is this repeated suggestion, for example, that she was put in charge of searching her own documents. The document production statement goes, if you want to look at it, I won't take you to it, it's at K tab 8 page 2171. It sets out the process, the lengthy process that was undertaken to search for these documents. So, for example, in relation to digital documents, the IT department, appropriate custodians were identified, the IT department then harvested emails, and those emails were sent in their original form to Taylor Wessing, who undertook the search. It's simply not correct to make those sorts of factual assertions which are used to justify the approach that was taken in this case. So I just draw out some of those points. But the main parts of my learned friend's submissions were about the non-party costs order. And the substantive submission there is that Mr. Al-Khalajle was not pursuing these proceedings for his own benefit, but it is accepted that he was a shareholder. And that is really, it's the economic realities that are essential. And you'll recall that the test in Dimmocks and the reference in Dimmocks to the New Zealand case, where it was said, well, a shareholder director won't be sufficient just because they're a shareholder director, that they will be liable for these costs. Something else is required, and an injection of capital is usually sufficient. So if you have those three pieces, they're in control and they fund and they stand to benefit as shareholder, then that is sufficient. And again, there are factual assertions made about the case which ought to be accurate, which are not. So for example, it said that the Vegie bar did not seek damages. They did. They sought an inquiry into damages. You can see that in the pleadings at B290. And then the final point, very briefly, if I may, is that you were taken to Goodwood and shown certain passages. You weren't shown certain other passages. And so again, you've got the law being presented in a way which isn't accurate. Because what you were taken, for example, to Taylor and Pace, you weren't taken to the passage in Goodwood which says, and the law has clearly moved on from Taylor and Pace. And I better show you that right now, because that's quite important and could make it put into a judgment. So if we go briefly then back to M2786, sorry, 2796 it was.
Paragraph number, please.
Sorry, 2796, paragraph 46. And you'll see this is where the explanation started, going through the authorities, and then said the court is reviewing the authorities culminating in Dimmocks, which have been concerned with that aspect. And then you were taken to the passage of Taylor and Pace. The earliest is Taylor and Pace, and you were shown relevant passage which appeared to suggest that a one-man company it wouldn't be sufficient. And then paragraph 48, this is a well-known passage, and you can already see the Court of Appeal beginning to depart from the approach taken in Taylor and Pace. I'd merely comment first that the passage is carefully balanced between the normal situation and the exceptional, and secondly, that the case of a company which is forced to defend a claim is not necessarily the same as the case of a company which initiates the claim. So the Taylor and Pace case was dealing with a defendant company, sole director shareholder company. And so you can see in this authority, Goodwood, the court is starting to distinguish that case. And it then goes through to deal with the Metalloy case, and then again, three matters that could be noted. And then the first is that the concept of the real party interested is advanced. And the second is that it follows that it is relevant to focus not only on the parties or non-parties bona fides, but also on his expected benefit or interest. So you're being given the impression that this test is all about whether or not it was bona fide in the interest of the company, when in fact the essential element is what is the nature of the interest of the third party. And it's quite clear from these authorities that being a shareholder is sufficient to give you that interest. That's the whole point of it. So if we go on, we see the references at paragraph 53. You see there, again, Re Northwest advances the position by focusing not merely on the bona fide belief, but also on whether the director, qua alter ego, is litigating for his or his company's interests. And then dealing with Dimmocks, you were taken through to the passage of that and dealt with this question of access to justice. But then right down at the bottom of that, you see that when they're doing so for their own benefits, the non-party, and this is 5 lines from the bottom, the non-party in these cases is not so much facilitating access to justice by the party funded as himself gaining access to justice for his own purposes. he himself is the real party to the litigation, a concept repeatedly invoked. And then as you go on, and then all of this commentary culminates at paragraph 59, which you'll find on page 2799. In my judgment, it's clear from these passages that the law has moved a considerable distance in refining the early approach of Lloyd's in Taylor and Pace, where a non-party director can be described as the real party seeking his own benefit, controlling and or funding the litigation, and even where he's acted in good faith or without any impropriety, justice may well demand that he be liable in costs on a fact-sensitive and objective assessment of the circumstances. And if you, just to make good this point that a shareholding is likely to be sufficient, I'm wondering whether I can do it from here, but if we go back to DIMICS, is probably the best way to do it. If you look at page 2796, sorry, 2786, and you'll see at paragraph 29, and this is the culmination of this assessment of all this previous authority. Paragraph 29, in the light of these authorities, their lordships would hold that, generally speaking, where a non-party promotes and funds proceedings by an insolvent company solely or substantially for his own financial benefit, he should be liable for the costs if his claim or defence or appeal fails. And then this is the relevant bit. As explained in the cases, however, that is not to say that orders will invariably be made in such cases, particularly, say, where the non-party himself is a director or liquidator, who can realistically be regarded as acting rather in the interests of the company, brackets, and more especially its shareholders and creditors than his own interests. So when they're talking about in whose benefit, for whose benefit, in whose interests is this director acting, one of the options, they're saying that they're making the distinction between a director who acts in his own interest, sorry, in the interest of the company, and therefore in the interests of the shareholders and creditors, and then on the other hand, a director who does not have that kind of interest. And so it's quite clear from that passage that a shareholding in the company, a substantial shareholding in the company, is sufficient to satisfy that requirement. And we see that, as I've said, if you go back to the passage at paragraph 26 on the previous page, which cites the New Zealand authority, which says it will be sufficient if you have paragraph 20 of that citation, a person who is a major shareholder and a dominant director in a company which brings proceedings, and then there's an injection of capital by that person for the purpose of funding the litigation. So that's why it's absolutely clear that if you are a shareholder, that will satisfy the test, or that part of the test, that you be acting in your interests. And in those circumstances, there are no access to justice issues, because as the Privy Council said in DIMICS, it's not so much about facilitating access to justice for the company, it's about accessing justice for his own purposes. And in a system which recognises that costs follow the event, that is a policy decision, then it is contrary to that policy to allow parties to take that sort of action in their own interests and not be liable for the costs that follow. So that's all I had to say, unless you had any queries about any of those points.
Okay, I don't have any. Roger, do you have any further questions?
No, thank you.
No, Chief Justice, I don't have one.
Okay, thank you very much, Counsel. I think we'll reserve our judgment and give us a few days to come back, and we'll tell you when we are ready. Give us a few days.
Sir,
Very much for your kind all your submission, which hopefully will make our life easier.
I hope so.
Find an answer to your the case. So thank you very much indeed, Mr. Montague Smith and Mr. Bowden.
thank you, sir.
That's to you. Mr. Justice Roger Giles and